Cabinet has approved the amendment of the Recognition of Customary Marriages Act. The new bill provides for the equal treatment of women in monogamous and polygamous customary marriages. In South Africa, women who entered into polygamous customary marriages prior to 1998 will now have joint and equal proprietary rights over marital property with their spouse. Well, for the significance on this, and just to unpack it further, we're joined now from our Cape Town studios by Professor Thandabantu Nhlapo, a traditional and customary law expert. Prof, good morning, and thank you very much for your time. How significant is this change in this law?
It is very significant because it closes a gap that existed as a result of the Constitutional Court deciding that discrimination on the basis of whether a marriage was before the Recognition of Customary Marriages Act and or after, that it was unfair, and that all women who are in customary marriages, whether they're monogamous or polygamous, should get the same property rights.
Yeah, I mean, some people will see this as a right step in the fight for gender-based equality, or as the country moves beyond gender-based discrimination. Exactly in practice, what does it mean? What will the women who are in such marriages benefit? How will they benefit?
They are going to benefit in this way that now all women married according to customary law will have the benefits of a marriage in community of property, when in the past the original idea was that you could not work community in a polygamous situation. So what it means really is that the whole disadvantage of women having to live a marriage with only the clothes on their back, because that is the customary way, or at least it was perceived to be the way of doing it, all of that is now out of the window. Protections exist for all women married according to customary law.
And one would imagine that by extension their children can also benefit.
Yes, of course. What has always been the challenge in trying to bring modern constitutional rights to bear on the position of women and children in customary law has always been the fact that it has been perceived, and I say perceived advisedly, because in fact it is distorted customary law that had the effect of marginalizing women and children. It was never real customary law, but the pendulum has swung back towards making sure that distorted customary law is no longer what rules the day.
Now, what would be required to be done? I mean, law is one thing, it's changed on paper. What, in your view, should be done? What would be required to be done to make sure that that distortion is really practically in day-to-day lives of these women done away with?
I suspect the courts in particular, which is where the battles are fought on a real life and real-time basis, are going to have to play a very strong role. You will recall that one of the problems currently in customary law is the method of ensuring that a marriage has in fact taken place according to custom. There have been so many cases where the law has been left, if you like, hanging, because people now are just not sure what the validity of a customary marriage should be based on. You remember the case of WHP, for instance. Now, what's the point I'm trying to make is that those new laws and those new rights are going to have to come through in the wash as the cases go through the courts. And finally, the issues will be settled. Right now, they are quite in flux.
Now, I mean, finally, Prof, I mean, you hear about all kinds of practices, like people who say, I've paid lobola, but some people who say, but lobola does not mean that customarily we are now married, but we live together after paying lobola, and then after the husband dies, his family starts treating the woman who lived with him after paying lobola as a stranger, and that she has no rights. Can such a case rely on this amendment to make sure that she gets the rights that she deserves?
Maybe not directly, because the amendment is simply bringing up to date what has been done by the courts in extending rights to women married under customary law, particularly polygamous ones, and particularly those before the Recognition of Customary Marriages Act. So it's indirect. What is the difficulty is the fact that that Recognition of Customary Marriages Act says that you are married if you are married according to your own living customary law. And what the courts have been struggling with is trying to make sense out of what is meant by the living customary law of the parties concerned. That is why you find people's interpretations of their own custom ranging very divergently, from those who say you pay lobola, you are married, and those who say no, it's in our living law that is not the case. Indeed, even if you don't pay at all, as long as there's an agreement on lobola, it's part of the marriage, but it's not the only part. So, as I say, eventually it will come out in the wash through the courts.
Thank you very much, Professor Nhlapo, talking to us about this new amendment of the Customary Marriages Act. Now,